Hi, everyone. Thanks very much for joining our webinar this afternoon. Lovely to see you all joining, and thanks very much. Today's Employment Law Lab is all about data privacy, which is why I'm here. We're covering top 10 data privacy issues that employers need to know about. What is the chat essentially? That is what today's webinar is all about. And then, of course, we'll have an employment law update at the end of today's session as well. So I think before we crack on, we've just got some housekeeping slides. So presenters today, my name's Jo McLean. I'm a partner and head of our data privacy team at Burness Paul. So I work in our technology and commercial division. So I suppose the first disclaimer is that I'm not actually an employment lawyer. But for that particular role, I'm delighted to be joined by my colleague Ilaria Moretti from our employment team. And Ilaria will be covering employment law updates towards the end of this session. So now that you've all joined the webinar, please just make sure that your kind of details are up to date. That just means that if you submit a question during the sessions, then we can get back to you afterwards if we don't have time during the session itself. I think everyone is muted, but if not, if you could please mute yourselves just to make sure that you're not picked up on the recording. And that's because today's webinar is being recorded. So if you have any queries about what happens to the recording, please check the privacy notice on the Burness Paul website, and that also should have been provided to you when you signed up for today's session. I think that's all of the housekeeping. So now I'm happy to kind of jump into today's session. So I understand that a copy of the recording will be shared, will be made available. The slides I think can be made available as part of that. So yeah, now we're kind of ready to kick off. In terms of the kind of top 10 issues I wanted to cover in today's session, we have all of those issues here. The first one I wanted to, I guess, start with is the new right to complain. So this is a new kind of statutory data subject right, which was introduced by the Data Use and Access Act, which came into force. Well, it's been coming into force kind of gradually over the last year, and the final date that the final element from a data protection perspective came into force was the 19th of June, and this introduced the new right to complain. So, some of you cynically might be saying, thought people complained about data protection quite a lot anyway. But actually, I suppose what the new regime is looking to do is to kind of formalize those rights to raise concerns, to make complaints against organisations about how personal data is being processed, about how rights requests have been responded to, about how personal data breaches have been managed. So the new right essentially gives any data subject the right to make a complaint if they have concerns that an organisation has infringed data protection law in how it's been handling their personal data. Um, there's not much more in terms of formalities for organizations to think about. I think most organizations that will be on this session, that work in data privacy, that work in kind of personnel, HR, human resource management teams will probably likely be in the habit of responding to inquiries or queries or complaints about data protection matters. I suppose really what this new right is doing is kind of formalizing that in statute. So you have to acknowledge requests within 30 days, you have to investigate complaints, you have to keep somebody up to date on the progress of your complaint investigation, and you have to provide a clear outcome. Um, whether that outcome is to uphold the complaint or whether it's not upheld, will depend on the circumstances. But that's kind of really the extent of the obligation. We've been helping some clients with putting in place complaints policies just to kind of document the process that will be followed when a complaint is received. And although this only came into force last month, maybe about 6 weeks ago, we're already advising on quite a lot of complaints. So it's definitely something that we're seeing a lot of. I suppose another thing that we're seeing a lot of, which I'm sure many of you on the call will also be seeing a lot of is AI generated subject access requests, or sometimes we're now seeing AI generated complaints. Sometimes you see AI generated erasure requests or rectification requests or objection requests. But I suppose DSARs are the kind of most common types of requests that we see. And I suppose, this is where you receive a DSAR, which has kind of not obviously been drafted by the person making the request. There are kind of various telltale signs. Quite often these requests are very long and very detailed. So, back in the day, maybe a couple of years ago, when we received DSARs, sometimes it was just, please can you provide me with a copy of my personal data or a copy of a specific document. Whereas now generally there's always a reference to the legislation. There's a request for all personal data, and then there's, including, and then there's a long list of bullet points of all different types of data, sometimes specific documents, but most often just kind of categories of information, whether it's reference to emails, WhatsApp messages, Slack chats, Teams messages, internal documents, handwritten notes, metadata, backups, etc., etc. We see quite a lot of these requests, and they will kind of repeat a lot of the statutory positions as well around extensions and kind of requirements to conduct searches and things like that. Um, I could probably do a whole hour, if not a whole half day, on managing AI DSARs. But for the purposes of today's session, I think probably the key takeaways to bear in mind is that you can't necessarily just ignore a request because somebody has decided to use the support of an AI tool to help them formulate their request. So it's not a reason to, ignore a request or anything like that. But I think what we find is kind of helpful is trying to make clarifications where possible. Um, as I say, most people use AI tools to help them create DSARs because, they know that they want access to their personal data and they want to make sure that they're not missing anything. So they use the help of a tool. Actually, sometimes engaging in more of a direct dialogue with the person can be helpful to kind of understand exactly what information they're looking for. Um, so that can be a helpful way to approach this. You might also want to think about whether or not an extension is appropriate. There might be more systems that you need to search. There might be more exemptions that you need to consider if requests are really broad. You might need specialist legal support. And those are all kind of, I guess, factors which can trigger a complex situation, which means you could be entitled to a bit longer to deal with the request. I suppose another point to bear in mind with AI generated DSARs is that it's worth bearing in mind that any response that you provide in relation to those requests could itself be uploaded into an AI tool because somebody might, upload the response and say, is this compliant? Does this give me what I'm looking for? Especially if you're giving somebody a large volume of information, they might then be using AI to help them process that information. And I suppose there's various risks associated with that, but I suppose what I would say is that we are now seeing people making AI generated complaints off the back of their AI generated DSARs. So it's worth being prepared for that and documenting, all the decisions that you've made during your kind of DSAR response process so you can be prepared for that. And I think as well, being kind of extra cautious about disclosing any third party personal data on the assumption that your response might be uploaded into an AI tool is kind of helpful to bear in mind as well. So, as I say, I could probably do a whole a whole session on handling AI DSAR issues, uh, but I'm sure I will gladly move on to the next topic in the top 10, which is privacy notices. So I think, you know, I'm sure you'll all be kind of aware of or responsible for kind of privacy notices. All organizations that have employees need to be transparent with their employees about how they're handling their personal data. And for most organizations, that transparency is achieved via an employee privacy notice. Um, what we have been working with quite a lot of clients with recently is kind of updating and refreshing those privacy notices. I think for some organizations, this might be a document that you've not really had to look at, potentially since 2018 when GDPR first came into force. Some organizations revised their notices around the time of COVID to deal with kind of additional processing of employee health data. If it's not something that you've looked at since then I guess a key recommendation from this session is to have another look because you may be using more AI tools internally, which may be processing personal data, which would need to be referred to. You might be doing kind of more monitoring of employees, which we'll come to. If your corporate structure has changed and you're now part of a bigger international group, there might be data flows that you need to document, or that you need to tell people about. It's really a good idea to refresh your notices regularly anyway, but if it has been a few years, it's worth making sure that they're still accurate and that you're still being transparent with employees about how you're using their data. And in particular, there is a requirement to tell people about their new right to complain. So this is all kind of looped together in that the new complaints regime has come in alongside everyone seeing more DSARs that are generated by AI. And actually, a lot of the AI generated requests do also ask to see a copy of privacy notices, or they embed questions which are actually best answered by providing a privacy notice rather than via a DSAR route. So making sure that kind of document in particular is up to date is really important. Um, the next topic that I wanted to touch on is data protection impact assessments. So, impact assessments are required where you're conducting any activity which potentially poses a high risk to individuals. So, any activity where there's maybe a higher risk of, a personal data breach occurring, or any activity which maybe involves kind of collecting more information about employees, or any activity which maybe involves certain activities. And actually, the legislation does call out certain activities which will kind of automatically trigger a DPIA. So I think, anything that involves kind of profiling or automated decision making will generally require a DPIA. Anything which involves kind of systematic monitoring of individuals would likely trigger a DPIA, and activities which involve kind of large scale processing of special category data, such as health information, would require a DPIA. So I would say in the past kind of couple of years or so, we've been helping more and more clients with DPIAs. I think just because onboarding of new technologies, new monitoring systems, new AI tools to make kind of even some high level workplace decisions are all kind of activities which can trigger DPIAs. And a DPIA is a really helpful document to kind of to show you're working, I guess. A lot of, one of the kind of key founding principles of data privacy law is accountability. And that's essentially just being able to show your compliance, being able to show you're working. And it's one thing to kind of implement new technologies or undertake new activities and deciding internally how you're going to protect people and putting technical organization security measures in place. But if you haven't written any of that down, it can be really challenging if you're then later challenged by an individual or a claim or the regulator to be able to show you're working to say, no, we did consider the data protection and the privacy impacts, and we decided, these were all the things that we did to make sure that individuals were appropriately protected. So DPIEs are really helpful for um, stress testing things as well. They're assessments that should ideally be kind of conducted at the outset of any kind of significant change management program, or before the introduction of any kind of significant new technologies. And I guess onto the topic of new technologies, responsible use of AI is kind of one of my topics here as well, which is again probably another one which could be an entire session just by itself. But I wanted to touch on it here because it is something that we are advising a number of clients on at the moment. I think and actually kind of responsible use of AI, I guess irresponsible use of AI does have data protection and privacy impacts. But I guess, AI risks are much broader than just data protection and privacy in that, it can put confidentiality obligations at stake. AI can pose intellectual property risks, brand and reputational risks. General kind of litigation and liability risks as well. Um, but equally, there's a huge opportunity as well. And I can imagine that many of you on the call today will, you know, be be in organizations where you're being encouraged to use AI as much as possible, where, there's clear efficiencies to be made. And I think responsible use of AI is not so much about, saying no to everything or yes to everything, but it's just making sure that, that you and others in your organization who are using AI tools have a certain level of AI literacy. So you're aware of, not necessarily into the technical details, but you're broadly aware of how these tools work, where their flaws are, where the risks are. I imagine, we've all had experience of AI hallucinations or AI kind of telling us the wrong thing. I think all you need to do is kind of start asking AI questions about a topic that you know inside out. You know, to understand, oh, actually, it can it can be quite flawed. I think we're in the habit of using AI to ask questions that we don't already know the answers to, and it comes back to us, and we think, wow, this is amazing. That sounds absolutely perfect. But if you ask it about something that you know about very well, you might be quite surprised at the level of quality that comes back. And that's not to say that, it shouldn't be used, but I think just having an awareness of those risks and making sure that you're stress testing the results of AI, that you're, not taking everything at its word, that you're kind of checking references, things like that. From a purely data protection and privacy perspective, we would generally always advise clients against using AI to process personal data unless you've done something like a data protection impact assessment. Um, I guess the use of AI, if you're using it to make decisions about people, can trigger a lot of the automated decision making rules under data protection legislation as well. And again, that's not to say that automated decision making it isn't allowed. It's definitely restricted when it comes to using special category data in an automated process, but broadly speaking, automated decision making is permissible, but there are just kind of certain safeguards that need to be in place. You need to make sure, for one thing, that you're transparent with people in your privacy notice about how you're using AI, and that you're giving people opportunities to contest decisions, to seek human intervention, to kind of challenge what the AI is deciding, and making sure that there's kind of a human in the loop in that process to either help reduce the likelihood of AI making the wrong decision, but also to make sure that if the wrong decision is made, that there's opportunities to rectify those decisions. So there's a whole kind of gambit of measures around responsible use of AI. I guess my takeaways for the purposes of today's session would be, I think having a clear policy in place. Um, we see quite a lot of organizations suffering a little bit from shadow AI, which is essentially where, you maybe have kind of clear prohibitions in place. You are telling employees, use this system, not that system. Make sure you're logging in with your company details. You're using the kind of closed network, enterprise, secure version of this AI tool. But actually, everyone's got their personal phones at the side of the desk or under the desk. And actually, if they don't like the answer from one AI tool, they're just going onto their personal accounts or a publicly available tool and kind of potentially using those AI tools instead. In a very broad nutshell, that's kind of the crux of the shadow AI issue that we're seeing. And I think in terms of whether or not you can take action for that kind of activity depends a lot on what your policies are saying about use of AI. And, while a lot of kind of AI risks can be addressed with just a really good, robust, acceptable use of IT systems policy, we are increasingly seeing clients looking for a kind of appropriate, responsible AI policy in place just so that AI is kind of, very clearly treated in a special way and that you can take, appropriate action where somebody is kind of misusing AI and that's leading to kind of consequences for the organization. I feel like I've been wittering on about AI for a wee while now, so I'll move on to the next topic, which I think I touched on previously, which is employee monitoring. So this is something again which is coming up kind of fairly regularly. I think because I mean, again, it kind of all ties into the AI conversation a little bit. We're seeing the use of AI wanting to be monitored to make sure that people are using AI appropriately. I think not everyone knows that kind of Copilot keeps a record of every prompt that you input into AI. And actually, if kind of admin teams do particular searches, all of that information, can be found usually. So there is an element of kind of monitoring use of AI systems. There's also various AI technologies on the market to help with employee monitoring. I think another trend that we're seeing is just a very kind of focused um, prioritization of efficiency over in some ways kind of anything else. So making sure that employees are being efficient. Um, there are technologies available, there are monitoring tools available that can help with that. But not all employee monitoring is just focused on efficiency and productivity and things like that. Some employee monitoring is kind of essential for safety reasons. So if you're working in a kind of regulated uh, or an environment where there are kind of very strict health and safety rules, then employee monitoring is essential to kind of make sure that you're complying with those other legal obligations. So we've been helping some clients in oil and gas in particular with different changes around, kind of uh, laws regulating kind of offshore workers and things like that. And actually, in order to be able to comply with those laws, you do need to collect a certain amount of health information about employees in particular. So we've been helping clients kind of work through some of the data protection issues that can crop up there. So again, when you're kind of implementing these other policies or other exercises around, use of different employee monitoring systems, it's worth bearing in mind that those systems will be collecting and processing personal data. So thinking about, do you need a DPIA? Is your privacy notice up to date? Is your data protection policy up to date? Who has access to the information that's being collected by the monitoring technologies? Are you satisfied that you have a lawful basis for that? Are there appropriate security measures in place, etc., etc.? There's always lots of questions to think about. I guess other employee monitoring we see as well. I guess sometimes it's monitoring health, as I mentioned. Sometimes it's kind of monitoring use of technologies. Sometimes it's things like monitoring use of vehicles. So to the extent you have employees kind of working remotely in different locations, um, using kind of company vehicles or their own vehicles for company purposes, then you might have telematics devices and things like that in those vehicles to make sure that um, ultimately so that that person can be contacted if there's a safety or a lone worker risk. But actually, sometimes the information collected by these technologies can be used for other purposes. So again, that's something which can have data protection implications that's worth bearing in mind. Um, I mentioned just now that, when you're considering use of AI or employee monitoring, you might need to have a think about what your data protection policy says. So I wanted to touch kind of briefly on DP policies because I think most of the kind of HR teams that we work with, I would say the data protection policy and the privacy notice are probably the two key documents that you sort of need to have and need to keep updated from a data protection perspective. And I guess they serve kind of slightly different purposes. I mentioned that the privacy notice is all about transparency. It's all about telling people how you're processing their personal data. The data protection policy is, I guess, more of a traditional policy. It's more about informing employees, what's expected of them when they are handling personal data in the course of their role. So making sure that there are clear rules in place around, not collecting too much data, making sure that, items such as DPIAs are being picked up, making sure that other types of assessments like legitimate interest assessments or transfer risk assessments are being conducted, making sure that there's kind of clear allocation of responsibilities for different members of staff. Sometimes you even have kind of very high level procedures around managing DSARs or managing personal data breaches within data protection policies as well. And sometimes they even have information on data retention, which is a topic all unto itself in a few minutes. But I wanted to flag this document because again, it could be something which you have in place and it's maybe just not something that's been looked at for a while. And again, it may need updating if operationally your organization's changed significantly in the past few years. It's just worth making sure that your data protection policy is reflective of the types of information and I guess what's expected of employees as well, and making sure that it links to things like your acceptable use of IT systems policies or your responsible AI policies as well. Um, I've also called it by another name on this slide, which is referring to it as an appropriate policy document, which is a term that some of you might have come across. So this is a term which is used in the Data Protection Act, not so much the UK GDPR, and it's a requirement to have an appropriate policy document in place if you're collecting and using special category data like health information for employment related purposes. So if you're relying on compliance with employment legislation as one of your kind of lawful basis for processing special category data, then it's a legal requirement to have an appropriate policy document in place. And for the most part, that is essentially, the ground that's covered by your data protection policy is essentially the ground that needs to be covered in an appropriate policy document. And they're not often two separate documents. But I suppose the requirements for an appropriate policy document are very much centered on use of special category data. So it's worth making sure that your data protection policy sufficiently covers that and, appropriately explains to employees that if they're handling special category data, they need to be super careful, essentially. And they need to make sure that, they're in contact with the DP manager or the data protection officer or the kind of member of the senior leadership team who's responsible for data protection, perhaps before collecting or using special category data. So that's just a bit of a kind of a reminder as well on, that is an essential document that you need to have in place and should be kind of reviewed and kept up to date every so often. The next topic is something completely different. Um, Apologies. So the next topic is all about international transfers. And I think specifically I wanted to kind of flag here about intragroup transfers, because we are working at the moment with quite a lot of clients on kind of managing their intragroup data transfer situations. Um, and I guess, for those of you on the call who maybe don't work in data protection all day, every day, there are kind of specific rules and requirements governing kind of transfers of personal data outside of the UK. The rationale for that is really that, the UK, certainly when it was part of the EU, was kind of one of the nations with, the we kind of helped lead the way in data protection. We were kind of very involved in European discussions. The founding of the GDPR, we were heavily involved in that. And certainly the kind of previous iterations of the GDPR, the kind of data protection directive. Um, the kind of UN conventions as well on protecting personal data. A lot of data protection laws we follow today have their roots in kind of the 70s and the 80s. They're not necessarily new laws as such. But I suppose the international transfer rules are looking at, from the perspective of when your personal data is held in the UK, it's subject to all sorts of fundamental protections. And if personal data is transferred to other jurisdictions, then those protections might be not as robust. So the starting position from which the law takes is that you can't transfer data internationally unless certain rules or measures or contracts or decisions are in place. And it can be a bit of an exercise to try and make sure that your transfers are appropriate. And I would say kind of a number of years ago, we did a lot of advice in this, on international transfers when it came to, I guess, kind of flows of customer data or in the context of kind of appointing an outsourced service provider. There would always be a question around where is the service provider hosting the information, what subcontractors or kind of others in their supply chain, how are they handling that information? So international transfers would kind of always be discussed there. And then I would say more recently, we're doing a lot more on kind of intragroup transfers, and actually kind of employee information is always essential to this. So if you're part of a wider group, but your group employee systems are all kind of hosted on one platform, you might be kind of the UK or European branch of a group that's kind of headquartered internationally. So all your employee data might be hosted at headquarters. You might be the kind of global headquarters of a group where all the kind of employee information for all the other territories is hosted with you. And it can be a bit of an exercise to kind of map out how to make sure that those intragroup data flows comply with data protection laws, because certainly what's happened over the past few years is that the rest of the world, is catching slash has caught up to the kind of the UK and the European kind of robust data protection laws. So we now have, lots of other territories, there are probably, well over 150 different kind of data protection legal regimes throughout the world now. And some of them are modeled on the GDPR and some of them aren't. And some of them have their own international transfer restrictions. So making sure that you're compliant with all the different regimes, documenting that appropriately, making sure that your transfers are compliant is really important. I would say that the biggest GDPR fine that we have seen to date from the Irish regulator, which was over 1 billion, was an international transfer issue. That was to do with kind of transfers of customer data rather than employee data. But the law doesn't make a distinction. So the laws which apply to transfers of customer data also apply to transfers of employee data. So it's, if you're part of a global HR group, it's worth kind of having a think about, do we have everything in place that we need to have in place to make sure that our international transfers are compliant. Um, I also wanted to touch briefly on data retention, which is something which I, yeah, it, it's the I was going to say problem that never goes away. It's not really a problem, but it is an issue which is constantly something that we're asked about. And I guess from my perspective in the data protection world, the position is kind of fairly simple actually. Data protection law essentially says, you should only keep data for as long as necessary for the reason that you collected it. And in an HR context, you normally are bound by whether it's employment legislation or limitation periods or prescription periods for claims. That's usually your barometer for how long you should keep personal data. And that's not an issue from a data protection perspective. I guess where data protection law comes in is this whole point around accountability, which is making sure that you are documenting, what personal data you hold, how long you keep it for, when it should be deleted. And then the other element to this is the kind of practical implementation. And I suppose I would say that, with everything kind of being electronic and cloud hosted, that's certainly the direction of travel. Data retention should actually be a bit easier to comply with because you can set kind of data retention periods within systems. You can, those with administration rights can kind of set those periods, or you can use kind of defaulted retention periods. Um, so there are kind of tools and measures in place to make sure that information can be automatically deleted. And again, it's just making sure that, someone is checking that those automated deletion procedures are in place. There might also be circumstances where you want to keep data for a bit longer. So making sure that there's flexibility to switch those automated processes on and off. Um, and I'd say, data retention, if you're not getting it right, if you're not deleting data regularly, it can it can come back to bite you because, we work on, as I mentioned earlier, AI generated DSARs all the time. And if you have an employee who's been with you for, 10, 15, 20 years, and they make a DSAR asking for absolutely everything, um, there's obviously probably things you can do to, design your searches to be reasonable and proportionate, but you might still end up, finding a huge volume of information purely on the basis that, there hasn't been automated deletion in place. If everything is just kind of defaulted to being kept forever, then, as we're generating more and more data for all of our tasks, especially actually because of AI, like I said, conversations with Copilot are quite often coming up in, search results for DSARs nowadays. So there's just more and more information to consider. So there is a kind of operational and, probably cost need to look at data retention as well as just a kind of purely compliance point of view, because, sometimes we respond to DSARs and then the response is, why are you even holding this information? And then that opens up, a whole other kind of avenue of correspondence with somebody. So data retention is kind of really key. And it's one of those painful things that once you've actually kind of identified all your data sets, the different systems in place, checked that there's kind of automated deletion, set up, then, then it's just an ongoing thing and the kind of initial pain is gone. And it's just something that you need to review and you need to update when kind of new systems are onboarded and things like that. But again, if it's not something that you've had a look at in a while, it's worth just kind of checking where you are with that because yeah, I mean the cost implications of keeping information for too long can be really significant. And then finally on personal data breaches. So, yeah, it's probably not possible to escape a whistle stop tour or a top 10 of data privacy issues without mentioning personal data security breaches. It's still something that we advise on a lot. At Burness Paul, we have a kind of a specialist cyber team, and they deal with the kind of very scary, high profile ransomware attacks. I suppose in my kind of data privacy, data protection team, we deal with a lot more of the kind of accidental human error, systematic access control type breaches where there's not necessarily a criminal or a malicious element to those breaches. But again, the law kind of treats those incidents the same. If you if a malicious hacker manages to get into your systems and they extract 20 spreadsheets containing payroll information, that is definitely a personal data security breach. If someone in an HR team attaches an unencrypted document and accidentally sends it to the wrong person, I guess the risk is maybe different, but it's still, a personal data security breach, and it still needs to be kind of considered in the same way. It may be that the risk associated with a human error or a non-malicious breach is much lower because quite often, if it's a contact you already know, you can reach out to them and say, this was sent to you in error. Please, can you confirm deletion? And you can kind of, definitely reduce the risk doing that. But depending on kind of the nature of the information, whether or not you are able to recover it, things like that, there are different risk factors that need to be considered. You might still need to report these types of issues to the ICO, and the individuals involved might need additional training. You might need to consider different technical measures that can be used to kind of help reduce the risk of those types of breaches. But I suppose that was kind of my main message on breaches, which is just to remember that this does include the big scary, ransomware attacks. It does also include the kind of accidental, non-malicious human error, accidentally just sending the wrong document to the wrong person, or forgetting to apply password protection, things like that, or accidentally setting a folder up so that the wrong person can access it, or forgetting to remove access controls when somebody leaves an organization. These are all kind of security issues that your teams might need to be aware of, and kind of thinking about the data protection implications of those. Um, I appreciate that was a relatively quick whistle-stop tour of all of those issues. I think we have had a couple of queries, but I'm conscious of time, so I'm going to pass you to Ilaria now to kind of give us more of an employment law update, and then if we have time at the end, I will try and come back to you on your questions. Thanks very
Thanks.
much.
Thanks very much, Jo. That was so interesting. I think the AI point in particular will be very relevant and useful for everyone. But I'm just going to cover a few specific and recent developments in the world of employment law. Now, as many of you will know, on the 7th of April this year, the Fair Work Agency was established and brought together enforcement functions that were previously exercised by multiple bodies. And its remit includes enforcement of employment agency standards and the enforcement of employment tribunal penalties. But the government made clear that over time, the Fair Work Agency will take on the enforcement of a wider range of employment rights, including things like holiday pay. So on the 30th of June this year, the government has published a consultation paper called Make Work Pay, Holiday Pay Compliance and Enforcement, and they're seeking views on the government's proposed approach to statutory holiday pay compliance and enforcement by the Fair Work Agency from 2027 onwards. So the proposed enforcement powers of the new Fair Work Agency represents quite a significant shift away from the reliance on individual employment tribunal claims raised by workers towards a model of state-led enforcement similar to the current national minimum wage enforcement regime. The consultation does not propose changes to holiday pay entitlement or calculation rules, but instead it focuses on how compliance will be monitored and enforced. So some of the key proposals from the consultation are that from 2027, the Fair Work Agency will be able to investigate employers, recover arrears and issue penalties. Workers will be able to make complaints directly to the Fair Work Agency, and that ability will sit alongside rather than replace the employment tribunal system. However, a worker cannot recover the same arrears from both the Fair Work Agency and an employment tribunal, and a tribunal may decide not to consider a claim whilst the Fair Work Agency is investigating the same matter. But importantly, the Fair Work Agency will be able to take a whole employer approach, reviewing compliance across the workforce rather than limiting investigations to the individual complainant. And it may also inspect compliance with holiday pay and national minimum wage simultaneously. In terms of the scope of their enforcement, the Fair Work Agency's remit would cover statutory holiday pay only, and that would include situations where holiday pay has been underpaid or not paid at all, or holiday pay has been incorrectly calculated, or an employer had refused statutory leave or had refused to allow that leave to be carried over. But additional contractual holiday rights above the statutory minimum will remain outside of their remit. The government also proposes that the Fair Work Agency should be able to investigate underpayments occurring at any point in the 6 years before a complaint is made, which aligns with the existing enforcement period for national minimum wage claims and the new obligation that was effective from April 2026 to retain holiday pay records for 6 years. However, the Fair Work Agency will only be able to enforce underpayments arising after the 18th of December 2025, which was the date that the Employment Rights Act 2025 received royal assent. In contrast, though, claims for holiday pay in an employment tribunal must be brought within 3 months of the underpayment or the last in a series of underpayments, with that timescale increasing to 6 months from October this year. So the significantly longer ability under the Fair Work Agency claim period means that workers who are time barred from bringing a tribunal claim might still be able to have their underpayment enforced by the Fair Work Agency. In terms of financial penalties, the government proposes adopting the same penalty framework that is used for national minimum wage enforcement. So there would be a standard penalty of 200% of holiday pay arrears that are owed per worker, up to a maximum of £20,000 per worker, with a minimum of £100 per case. But they are proposing an early payment discount, or so a 50% reduction if the arrears and half of the penalty are paid by the company within 14 days. Now, those penalties would be separate to the arrears that are owed to the worker themselves, and the penalty payments go to the government. So the consultation emphasises that employers who identify and rectify arrears before a formal investigation begins would ordinarily avoid paying a penalty. They are also proposing or considering extending the current minimum wage naming regime to holiday pay underpayments. So that would create quite potentially significant reputational risks for large employers. But the model is meant to be deliberately supportive. So the Fair Work Agency intends to provide guidance and educational materials, and the consultation asks whether the Fair Work Agency should provide additional compliance tools such as a holiday pay calculator or a digital assistant to help employers and workers understand their rights and obligations. They also say they will encourage employers to self-correct before any formal investigation begins. And the intention is that they will only use notices of underpayment and penalties where employers fail or refuse to comply. But the focus is really on lower paid workers. It makes clear that whilst any worker can bring a claim to the Fair Work Agency, the government's primary focus is those in lower paid roles or in precarious employment, such as part-year workers. And the government is considering legislative and operational means to focus the activity for that purpose. So the proposals include putting a cap on the maximum arrears that a worker can receive from the Fair Work Agency enforcement, and that is to encourage higher paid workers to enforce their rights via the Employment Tribunal, therefore freeing up the agency's time to enforce pay for lower earners. Or they're also considering triaging holiday pay complaints received by the Fair Work Agency to focus compliance and enforcement activity on the lower paid earners. They're also considering targeting proactive compliance and enforcement by geographical area with higher concentrations of lower paid or precarious workers. So it'll be interesting to see where the final decision lands on that point. But as it stands, many employers assume that holiday pay compliance is low risk because comparatively few tribunal claims are brought. But this consultation suggests that the government considers non-compliance to be more widespread than the tribunal statistics indicate, and they want to increase the enforcement activity accordingly. So the greatest risks of being non-compliant with holiday pay rights are likely to arise where holiday pay remains technically complex, including where there's overtime or variable pay arrangements, there are shift premiums and allowances, or irregular hours workers or part years workers. But the ability of the Fair Work Agency to review 6 years of records means that historic errors could generate significant arrears and penalties in the future. So for HR and in-house legal teams, the key message is to prepare for greater scrutiny, record-keeping requirements, and potential financial and reputational consequences if holiday pay is not calculated correctly. Now, the consultation closes on the 22nd of September, and it will be interesting to see the government's final decisions on each of the issues. However, as we know, the Fair Work Agency enforcement is coming. There are some practical steps that you can take now to try and get ready and address the potential risks. Those steps include conducting a holiday pay audit, and that means reviewing whether holiday pay calculations accurately reflect the current legal requirements and are applied consistently across the workforce. You can also be reviewing record keeping practices because since April this year, employers are required to keep adequate holiday pay records for 6 years. So organisations should ensure that they can readily demonstrate compliance by keeping records of entitlement to annual leave, entitlement to pay for annual leave, the payments that are made, and payments that are made in lieu of holiday on termination of employment. Because poor record keeping will make defending a Fair Work Agency investigation significantly more difficult. Employers can also consider strengthening their internal complaint processes to make it easy for workers to raise holiday pay concerns internally so that issues can be resolved before matters are escalated to the Fair Work Agency. And we'd also encourage employers to train HR, payroll, and managers in respect of holiday pay entitlements and pay generally, because many holiday pay errors arise from misunderstandings rather than from deliberate non-compliance. And that training can include matters such as holiday entitlement, carryover of holiday rights, holiday pay calculations, and the rolled up holiday pay rules. Of course, if we can be of any assistance in preparing for the changes to holiday pay enforcement, then please do get in touch. I also just wanted to cover some practical tips from two recent cases that have gone through the Employment Appeals Tribunal. The first is the case of Shanda Shikarapa versus Wipro Limited. And in that case, the claimant worked as a practitioner sales farmer in the Cloud and Infrastructure Services division in Wipro, so it was a sales role. And in March 2020, the company introduced a new bonus scheme. Now, during a presentation, employees were told that eligible sales staff could receive up to 1% of invoiced revenue generated from winning new business during the first 12 months of a client relationship, but that was subject to approval from a sector lead. It was said that incentive payments were to be calculated in US dollars, but would be paid in an employee's local currency. Now, before the presentation, the claimant in this case's line manager had told him that if he managed to secure a contract with the John Lewis Partnership, then he would receive this new bonus, and it would probably make him one of the highest paid salespeople in the company globally. So the claimant did then play a significant role and managed to secure a major contract with the John Lewis Partnership. And so shortly after the deal was agreed, his sector lead approved the full 1% bonus, and that was communicated to the claimant. However, several weeks later, the requirement for a further level of approval and a cap of 150,000 US dollars were applied to the bonus scheme. And internal correspondence showed that some managers did question whether such a cap existed and did note that if it did, it should have been communicated from the outset. But ultimately, the claimant received a bonus that was capped at 150,000 US dollars. But had the full 1% formula been applied, the payment he would have received would have been over £500,000. So he brought an employment tribunal claim for unlawful deduction from wages. And the key question for the employment tribunal was whether the claimant had acquired a legal entitlement to the bonus once the sector lead approved the payment under the terms that were originally communicated. Now, at first instance, the employment tribunal rejected the claimant's claim of unlawful deduction from wages, having concluded that the claimant's entitlement had not crystallised when the sector lead gave his initial approval. In the tribunal's view, there was no legally enforceable entitlement that arose until the employer formally communicated the amount of the bonus that would be paid, and by which time the need for further approvals and the cap had been communicated. However, the claimant appealed, and the Employment Appeals Tribunal allowed the appeal. So they found that in March 2020, the presentation set out the relevant conditions for the bonus, and those conditions required approval from the sector lead. So once the claimant secured the contract and got sector lead approval, he should have received the full 1% bonus because the discretion that was built into the scheme had been exercised at that point in the claimant's favour. So at that point, the claimant had become entitled to a payment that was calculated by reference to 1% of the client revenues that were generated during the first year of the contract, and that was the rules that were set out in the presentation. And the Employment Appeals Tribunal held that the company was not entitled to suddenly move the goalposts by later introducing additional approval requirements or imposing a cap that had not been part of the original terms. And the evidence showed that neither the cap nor any higher approval requirement had been communicated when the scheme was introduced or before approval was initially granted. So the Employment Appeals Tribunal substituted its own view, holding that the claimant was entitled to receive 1% of the first year's revenue from the contract, less the amount that had already been paid. So the case provides an important reminder that even when a bonus arrangement is described as discretionary, employers cannot retrospectively introduce new conditions or limitations once the employee has satisfied the conditions that were originally communicated and the relevant discretion has been exercised. It also highlights the importance of properly documenting the full terms of a bonus scheme because the presentation to the employees did have a caveat in it saying this document serves to provide a broad overview, it's not a substitute for a policy document, and it cannot be considered complete or accurate without reference to the policy document. However, that didn't stop the bonus becoming due to the claimant because no such document appeared to have been produced. So any caps, approval processes or eligibility conditions need to be set out expressly from the outset and communicated to employees before any work to which the bonus relates is undertaken. The second case I wanted to cover is the case of XX versus YY. Now, the claimant in that case was an assistant head teacher who had been employed by the respondent school since 2014. Between approximately 2015 and 2018, she was involved in a coercive and controlling relationship, and during that relationship, she sent a message of a sexual nature to a person that she believed to be under the age of 18. Now, the employer accepted that she sent the message because she feared that she or her children would suffer serious harm if she didn't send the message. But the claimant didn't report the incident to her employer or follow safeguarding procedures, and the matter only came to light around 18 months later when her former partner reported it to the school. So, following an investigation and disciplinary process, the claimant was summarily dismissed for sending the inappropriate message and for failing to report a safeguarding concern. So the claimant brought an employment tribunal claim for discrimination arising from disability, unfair dismissal, and wrongful dismissal, but all of those claims failed before the employment tribunal. Now, the claimant then appealed, but the appeal was limited to the complaint of wrongful dismissal only. And just some helpful context in terms of the legal issues that apply there is that wrongful dismissal is a contractual claim that can arise where an employer dismisses an employee without giving the notice that's required under their contract. So in the context of wrongful dismissal and cases of alleged gross misconduct, the key question is whether the employee's conduct was serious enough to justify summary dismissal without notice. And if not, the employee may be entitled to recover their notice pay. But that has to be assessed on an objective basis. So although the Employment Tribunal acknowledged that the teacher had acted under duress when sending the message, it held that the conduct nevertheless objectively amounted to a repudiatory breach. In its view, the claimant's motives did not alter that conclusion, so the wrongful dismissal claim was therefore dismissed. However, the Employment Appeals Tribunal allowed the appeal and has remitted the wrongful dismissal claim back to the same tribunal for reconsideration. Because the Employment Appeals Tribunal held that the tribunal had erred in law by effectively treating duress as irrelevant to the question of whether the claimant's conduct amounted to gross misconduct. The correct approach was to consider all of the relevant circumstances that bear upon that objective assessment of the conduct. So, drawing on authorities concerning fundamental breaches and mutual trust and confidence, the Employment Appeals Tribunal emphasised that context can be relevant, and while an employee's subjective motives will not usually determine the outcome, the circumstances surrounding the conduct may influence how a reasonable person would objectively assess it. The appeal tribunal stated that the tribunal should have asked whether the claimant's conduct, viewed in light of the pressure that she was under and the employer's safeguarding expectations, was so serious that it destroyed the trust and confidence necessary for the employment relationship to continue. But importantly, the Employment Appeal Tribunal did not decide that the claim for wrongful dismissal should succeed. It did recognise that there was more than one possible answer to that, and so it's remitted it back to the tribunal, who will need to weigh both the significance of the alleged duress and the claimant's continuing failure to report the incident over the following 18 months, despite her senior safeguarding responsibilities. So the case highlights that when assessing whether conduct does amount to a fundamental breach of contract which justifies summary dismissal, tribunals need to consider the circumstances in which that conduct occurred, including evidence that the employee acted under duress or extreme pressure. And so they'll need to consider the context carefully and distinguish between the act and any subsequent conduct. But employers should therefore document the reasons behind disciplinary decisions, and where mitigation is raised, employers should always ensure that disciplinary outcomes clearly explain that mitigation has been considered and why it does or does not affect the conclusion that summary dismissal is justified. So that's all in terms of the case updates, and they may leave some food for thought. There are, of course, lots of changes coming into effect soon under the Employment Rights Act, and our team will be hosting a webinar on Wednesday, the 26th of August, covering the changes that will be coming into force under the Employment Rights Act in relation to harassment. That is to prepare employers for the changes that are coming in from October this year, when the duty to prevent sexual harassment will be strengthened and requires employers to take all reasonable steps to prevent it. And at the same time, employers will also become liable for third-party harassment, which covers all forms of harassment, not just sexual harassment, unless they can demonstrate that they took all reasonable steps to prevent it as well. So that is a paid-for session and will include some template policy documents. But if you would like details, please do get in touch, or you can sign up through our website. I think that brings us to the end. I am conscious of time, so I don't think we'll have time for any questions, but we will be happy to follow up directly. So if you leave any questions in the chat box, or you can contact Jo or I afterwards directly, and we'll get back to you. But otherwise, thank you very much for joining, and enjoy the rest of your day.